So in the more standard world, hopefully, that we live in, where does the Fifth Amendment place the burden of proof of guilt or innocence, and why does it do this?
The notion of guilt or innocence, or the requirement that guilt be proven, that burden is always on the prosecution. Here's the basic notion. If the prosecution, the government, wants to put me in jail, or wants to find me or any other citizen, or any other person for that matter, guilty of a crime, it's got to prove it. And the only way that it can be forced to prove it is for it to have the burden of proof in that circumstance. So in theory, our defendant need not say anything in court. In fact, oftentimes the defendant does not provide any affirmative information. Of course, the counsel for the defense will cross-examine witnesses, but the defense doesn't have to put on a case at all. It's all on the prosecution. If the prosecution wants to put someone in jail or wants to convict someone of a crime, it has to do all of the heavy lifting in order to prove that, in fact, the individual deserves to go to jail, be fined, what have you.
Is the protection against self-incrimination limited to criminal proceedings, or does it apply in non-criminal proceedings as well?
The right against self-incrimination, the privilege against self-incrimination, applies in any circumstance where one may have to provide information that in fact incriminates. So whether the individual is the defendant, whether the individual is in front of a grand jury, whether the individual is in front of Congress, for example. It's one of the reasons why folks simply say, I will rest on my Fifth Amendment rights, even in circumstances where they're not testifying at trial. So the right against self-incrimination applies wherever you happen to be. It may look a little different depending on where you are, but it still applies wherever you may well be when government tries to get you to say something that may lead to information that may well incriminate you.
Can you comment a moment about the right against self-incrimination and how it's related to the notion of limited government and the rule of law?
Sure. In terms of the right against self-incrimination and how it's related to the rule of law, the idea is that we still exist under laws. We're not government of men, we're a government of laws. And in circumstances where we say that the government has to prove something in order to take a harmful course of action against us, it's always going to be up to the government to do that on its own. We can't allow the government, at least the argument is we can't allow the government to invade our own personal mind and space in order to get the information that the government should already have if the government is going to try to put us in jail. Now, that doesn't mean that we can't waive our rights. It doesn't mean that we can't, just for personal reasons, decide to confess, clear our conscience, unburden our soul. It does, however, mean that the government has to be limited in terms of what it can do to us in order to get the information that the government ought to have before it tries to convict us of a crime.